Then we got another guy in custody, Dusty Hicks.
This case opens like many routine courtroom mornings. But don't let the calm tone fool you. What you're about to see quickly turns into a complicated mix of homelessness, mental health concerns, repeated trespassing complaints, and a judge trying to balance compassion with public safety. Our defendant, Dusty Hicks, isn't facing violent charges at the outset. Instead, he's trapped in something far more common and often more tragic. A revolving door between jail, the streets, and misunderstandings about where he's legally allowed to be. Judge Middleton recognizes him immediately, which already tells us something important. This isn't his first appearance. And when a judge remembers you, that usually means there's a pattern forming. And the tension here isn't just about law breaking. It's about whether the system can help someone before the situation escalates further. As we move forward, watch closely. Is this simply a man ignoring court orders, or someone genuinely confused about his rights and circumstances? And here's a question for you right at the start. Do you think courts should prioritize punishment or intervention when someone keeps reappearing under similar circumstances? Because today's decisions will shape not just this case, but what happens to Mr. Hicks once he walks out those courthouse doors again. Let's see how this unfolds.
Good morning, sir. Are you Dusty Melvin Hicks?
Yes, sir.
Mr. Hicks, I'm Judge Middleton. I think we've met. You're here on 2 trespass charges. Let's take a look at these. We just had a lady that was here on 2 different trespasses. You got a ticket on April 20th for trespass. Let's take a look at that one. That is the Goodwill store in Three Rivers. I think you've been trespassed from that whole plaza. You didn't show up. I did a bench warrant with a hold. Let's see how long you've been in jail. 17 days. You also have a felony case pending. Mr. Tim George is the city attorney for Three Rivers. Mr. George?
I have a felony with him. Do you mind if I sit up?
No,
here?
certainly.
I think there may be some.
All right, well, let me get his other case. Then he has another trespass, which is 24371. And then he has a felony resisting obstructing. Mr. John Bush has been appointed to represent you on the resisting obstructing case. And then we have these trespass cases, and I just lost Mr. George. Mr. Bush, what's the status here as far as you know?
Well, he's in jail right now. There's a misdemeanor offer on the resisting and obstructing case. I have concerns about his competency based upon my discussions with him. I don't know if the forensic center is the appropriate direction to go at this point.
Well, let's talk a little bit.
No. And Judge, I was just checking to make sure that you had the pretrial paperwork.
Yeah, I do. Thanks, Tim.
Yeah. Right.
24663 OM and 24670 OM. All right, we've got a dilemma here. Mr. George, absent any other issues, would you dismiss 2 trespasses for a plea to 1?
Yeah, they're all the same place, Your Honor. They're all 3 at that strip mall. But I will just say that we did have an initial pretrial last week.
Right here, we see courtroom efficiency in action. Trespass cases like these clog local court dockets across the country, and prosecutors often streamline them by offering plea deals. Plead guilty to 1 charge and the rest disappear. From a legal standpoint, it saves time and taxpayer money. For the defendant, it often means getting out of jail faster. But notice the judge's tone. This isn't just paperwork to him. He's already sensing that something deeper is going on. Mr. Hicks has been in jail 17 days already, and the judge is weighing whether continuing this process actually solves anything. There's also another layer here, a pending felony, resisting, and obstructing case. That changes everything. A simple trespass might be minor, but if police involvement escalates, the consequences get much more serious. And the judge is trying to find a resolution that clears minor charges while also addressing bigger concerns, including Mr. Hicks's ability to understand what's happening. And here's the tricky part. Sometimes plea deals are accepted not because someone agrees they're guilty, but because they want out of jail. Would you take a deal just to go home, even if you felt misunderstood or unfairly treated? That tension is about to become very clear as Mr. Hicks explains why he keeps going back to the same location.
I had some of those same concerns. I knew that he had this felony case today with Mr. Bush, so that's why I asked for the pretrial to be today.
Mr. Hicks, you're here. You've been in jail for 17 days. You keep going over to the Goodwill store and you're going over there and they told you not to come back. Then it ended up, you got into a scuffle with the police and you got charged with resisting, obstructing. Where have you been staying?
I was just staying around the Goodwill area at that time. Goodwill themselves seem to be okay with me there. Dollar General does. They all seem fine. They keep asking why the police are bothering me. They say they don't call the police. From my family and the relations to Goodwill, the family of Goodwill and the Dollar General, and the history of my name and of Dusty, I should have a...
Now things begin to take a turn. Listen carefully to what Mr. Hicks is saying. From his perspective, businesses aren't bothered by his presence. He believes police action is unnecessary or based on misunderstandings. But the court records show repeated trespassing complaints, meaning property owners or management have told authorities otherwise. This disconnect is critical. Legally, trespass doesn't require personal confrontation every time. Once someone is formally banned from a property, returning can lead to charges even if employees don't personally object at the moment. But then Mr. Hicks moves beyond misunderstanding into something more concerning, claiming ownership or heritage rights tied to sidewalks in nearby areas. This is where Judge Middleton starts recognizing a possible mental health component. The judge isn't mocking him. He's trying to determine, is this defiance, confusion, or delusion? And from a broader social perspective, this is where homelessness, mental health, and criminal law collide. Police are often responding to behavior that might actually require social services intervention instead. At this point, viewers might wonder, is the system helping Mr. Hicks, or just cycling him through arrests? The judge now faces a difficult choice. Enforce the law strictly or slow things down to understand the root problem.
right of being able to be around the Dollar General and Goodwill for over 100 and some feet, which means I wouldn't be trespassing.
Where do you actually stay?
I'm waiting for Keystone.
But I mean, right now, are you staying in the field behind Goodwill?
It would be off to the side of it, yeah.
All right, that's what they don't like.
There, off to the concrete, not the field.
But it's not your field.
No, I don't know. TSC and me have agreements for them mowing the grass there and up to the fence line there. And the sidewalk was laid by me when I was a child, but means the sidewalk is separately owned than the empty building they said I was trespassing at. It's not same affiliated as the building. There's a stamp on the ground. I do have a picture of it on my phone, but it states that I do own the sidewalk. And also the parkway there gives me rights to stay there as well for my heritage rights. And the fence used to be 5 to 6 inches from the building, not the fence that's in the field. So anywhere from that 5 inches or 6 inches from the building back to some apartments is considered property of heritage of Dusty.
Property of what?
In the heritage of Dusty Hicks,
Okay.
which states on a lot of the buildings.
Where are you from originally, Mr. Hicks?
3 Rivers, Michigan.
Who are your folks?
Terry L. Hicks and Carol L. Hicks.
Did you go to Three Rivers High School?
Yes, sir.
What was your graduation year?
95.
Well, then it says you resist obstructed a couple of Three Rivers police officers. What is the misdemeanor offer?
Attempted out.
What have you done since you got out of high school?
Employment, raised a family.
Okay, doing what kind of stuff?
Construction down there in Middlebury.
Okay. Well, here's the dilemma we're in, Mr. Hicks. You've got 3 trespasses. You're staying on property that isn't yours. There's no such thing as the heritage of Dusty Hicks that would allow you to have some ownership of this. They don't want homeless people camping behind these strip malls, so the city keeps citing you for this.
They said I
All
could.
right, so the city attorney has offered to dismiss 2 of the trespass counts if you plead to 1. In which case I would give you 17 days in jail, credit 17 days.
This is one of the key reality check moments in the hearing. Judge Middleton speaks plainly, cutting through confusion to establish legal reality. Property ownership doesn't work the way Mr. Hicks believes it does. Heritage, family history, or past connections don't grant modern legal rights to private commercial land. And notice something important. The judge isn't cruel here. He's direct but measured. He's trying to help Mr. Hicks understand why these charges keep happening. The city isn't targeting him personally. Businesses simply don't want people camping behind their buildings. But this creates a recurring problem. If someone has nowhere else to go, telling them not to return doesn't magically give them housing alternatives. That's why these cases repeat nationwide. And the judge now faces a practical decision: clear minor charges and let him go, or pursue mental evaluation that could keep him jailed longer. Neither option feels perfect. And emotionally, this moment shows 2 worlds colliding: the legal system's rules versus someone living day-to-day survival. The judge's concern is becoming clear. If released, will Mr. Hicks go right back to the same place and restart the cycle? We're about to see how that dilemma shapes the next decisions.
The other charge is a felony, punishable by up to 2 years imprisonment, 2 counts. The prosecutors agreed to dismiss both of those counts for a plea to attempted to resist or obstruct a police officer, which really isn't that hard to do. My concern, if we send you to the forensic center for a psychological evaluation, you're gonna be in jail for months. It'll be October before we get the result back. So I can't tell. You seem intelligent. You understand everything I'm saying. You're clearly answering my questions. Been in jail for 17 days. You're not under the influence of any drugs or alcohol. Do you take any prescription medication?
There's no reason to.
All right. So do you understand everything I'm saying?
We're having a conversation.
Okay. Well, the difference is if you plead to these charges, I can let you out of jail. If you don't, we're going to set some further proceedings and you could be here for a while. So let's start with the trespass charges. Do you acknowledge that the city of Three Rivers had told you not to be on those properties?
The police had.
This is where pressure subtly builds inside courtroom negotiations. Judge Middleton lays out the practical reality. Take the plea and go home, or fight the charges and stay locked up longer while proceedings continue. To viewers, this may sound like a simple choice. But imagine being in jail already for over 2 weeks, uncertain about housing, employment, or mental health treatment. Decisions made under those conditions aren't always clear-headed legal strategies. Sometimes they're survival decisions. And notice how defense counsel steps in, suggesting an evaluation before any plea is entered. That's significant. Lawyers are ethically bound to ensure their clients understand consequences before pleading guilty. So now the court must ask, is Mr. Hicks making rational legal decisions, or does he need assessment first? This moment shifts the hearing away from simple trespass resolution into something much bigger: competency. And here's something to think about. Should courts delay quick resolutions if there's concern someone doesn't fully grasp the situation, even if it means keeping them jailed longer? That question doesn't have an easy answer, and the court is about to wrestle with it in real time.
But they never showed me or the owner was never there to state that he called. They said that there was.
All right.
I don't know if it was a real phone call or not. That's, you know.
All right, so
Like, someone could be just mad at me
All
because
right.
they steal things from me down there.
the problem is, if I let you out of jail, you're gonna go right back.
Well, I don't want to go right back there, but I do my grocery shopping there.
Very good.
No, I'm going to Keystone as soon. I mean, if I, you know.
All right,
I mean, I
so
don't know
are
if
you
they're gonna let
willing
me
to
stay
admit
there.
to one of the trespass charges,
Your Honor,
Ms. Jackson?
just for the record, attorneys to my left, Mr. Bush and Mr. George, have more information than I do. But for the record, given even the balance of what you were discussing, I do believe he should have some kind of assessment before he enters any plea.
Well, we're not gonna do a forensic evaluation on 3 trespasses. We may do a forensic evaluation on the resisting and obstructing.
And I realize he has these other felonies, and so perhaps that would be the basis for that. And I realize the trespass is kind of stretching it, but because he has that felony, he does have that option. And so I'm putting that on the record, that I think he should have that option before any plea is entered on any of these cases.
Does that mean like counseling?
Pardon me?
Does that mean
Well-
like counseling?
Yeah.
I've had counseling.
Well, they're
No, no, no,
No,
we're
they're not
talking
needed.
about
Oh, when I
a,
had counseling
Okay, but.
3 times in my life.
well, all
So
right,
maybe you still need a little bit.
Ms.
They said I'm
Jackson,
fine.
Okay.
are you concurring with their proposal that we get a forensic evaluation?
No, I've
No,
had,
just a minute,
No,
Mr.
no,
Hicks.
no, he's
'cause
talking to me.
oh,
That's okay. Yes, Your Honor, and well, whatever the, I'm not sure where the other cases are presently because I wasn't a party to it, but it sounds like that there was contemplation of asking for that or going in that direction on the felony case. So if that's the case, he's not, it would apply to, at this point, to the misdemeanor, even though eventually maybe these will be outright dismissed. I don't know, but
Now the legal gears start shifting toward competency concerns. Competency isn't about guilt or innocence. It's about whether someone understands court proceedings and can help their attorney build a defense. And this matters because forcing someone through trial who doesn't understand what's happening violates constitutional protections. But here's the catch. Evaluations take time, sometimes months. During that time, defendants often remain jailed, especially when courts worry they'll reoffend or repeat behavior. Judge Middleton openly acknowledges the system's strain. Mental health resources are limited and forensic centers are backed up. This isn't just one man's case. It's part of a larger crisis. The judge is searching for a middle ground, help without unnecessarily locking someone away. But compromise options aren't always available. At this point, viewers may feel sympathy or frustration, maybe both. The court wants to help, but every option seems imperfect. And watch closely. This hearing is slowly transforming from a criminal proceeding into a mental health intervention decision. That shift will shape everything that follows.
if he's not competent for the felony, he's certainly not competent for the misdemeanor plea.
I would, all right. I don't
Is there a way, excuse me? I completely agree that it's gonna take months. That's why I didn't actually make that. I raised it as a concern. Is there a way to be looked at as pivotal and maybe get an update or whatever? We can move forward with that.
Well, we'll leave it on for prelim and see if we can get Lisa or somebody to deal with them at, so I'll leave a felony R&O case set for prelim. For July 2nd. Well, yeah, that doesn't happen magically.
Right.
Perhaps as his defense attorney, you could contact Pivotal and say,
I understand they're really behind, so I don't mind trying. I think Lisa has a better chance, but I would. contact
yes, I would
Lisa.
start with Lisa also. But Mr. Hicks,
Yes, sir.
issues here. If you're sent to the forensic center for a psychiatric evaluation as to your competence, your competence has to do with what is your state of mind now? Do you understand the nature of the proceedings? Are you able to assist in your defense? I've been having a nice conversation with you. You're polite, you're respectful, you understand everything, but you may have some baseline delusions that you own this property and you're causing a recurring problem in Three Rivers. But if I do that, you're going to be in jail for months.
This is one of the most delicate moments in the entire exchange. Judge Middleton speaks carefully, trying not to insult Mr. Hicks while still confronting what he believes is the underlying issue. Competency questions are tricky because the person involved often genuinely believes their version of events. From Mr. Hicks's perspective, his claims about heritage and property rights make sense. From the court's perspective, they don't match legal reality. And the judge also highlights another uncomfortable truth. If he orders evaluation, Mr. Hicks could remain in jail for months waiting for assessment. So the judge isn't eager to take that step, but he also can't ignore repeated arrests. This moment shows judicial discretion in action. The judge is balancing compassion with responsibility to the community. And it's important to notice how respectful the conversation remains despite disagreement. The judge listens, explains, and avoids humiliation, something viewers don't always expect in courtrooms. But the tension is building. If compromise fails, the next step will be unavoidable: formal competency evaluation. And we're getting closer to that turning point.
There may be some middle ground short of doing that. Plus, that's a very valuable resource. And there isn't enough of it to go to explore some mental health intervention here and continue all of these.
I've already been to counseling before, and,
Yes.
you know, apparently I didn't need them. I'm here, I mean, not here, but
Well, you're living on the street. You're estranged from your family.
well, my parents are passed on. I
Okay.
don't get along well with my brother. My grandma's, she in the old folks home living with my uncle,
Who's your brother?
Buck Hicks,
Okay.
Willard, Virginia King, and my grandparents. But they're all dying, they're getting old.
Well, Buck Hicks is old.
He's getting old. He's 7 years older than me.
I remember years ago, I dealt with him on an issue. All right, 1 o'clock. Mr. George, you don't need to be back because you've made a plea offer of 1 count.
Yes, sir.
On count of trespass. All right, Mr. Hicks, we're gonna work on this. Probably someone from Lisa is named Lisa is gonna be contacting you at the jail and see what our options are.
I'll contact Lisa today.
All right, thank you. You're good to go.
At this stage, Judge Middleton tries one more attempt to avoid locking the case into a lengthy forensic process. By bringing in a jail mental health liaison, the court hopes intervention might stabilize the situation without months of delay. This approach reflects a growing trend in courts nationwide, using mental health professionals early rather than relying solely on punishment. But here's the lingering concern. What happens once Mr. Hicks is released? Housing insecurity remains. Employment remains uncertain. And the location he keeps returning to is still off limits. Without support systems, people often return to familiar places, even if those places lead back to court. So right now, the judge is buying time, hoping resources can help redirect Mr. Hicks before escalation continues. But we're only halfway through this story. Soon, We'll see whether these efforts succeed, or whether the court must take stronger action. And coming up, things get more serious as additional charges and longer custody periods come into play, pushing the judge closer to a final decision.
Do you understand the nature of the proceedings? Are you able to assist in your defense? I've been having a nice conversation with you. You're polite, you're respectful, you understand everything, but you may have some baseline delusions that you own this property and you're causing a recurring problem in Three Rivers. But if I do that, you're going to be in jail for months. There may be some middle ground short of doing that. Plus, that's a very valuable resource. And there isn't enough of it to go to explore some mental health intervention here and continue all of these.
I've already been to counseling before. And,
Yes.
you know, apparently I didn't need them. I'm here, I mean, not here, but
Well, you're living on the street. You're estranged from your family.
well, my parents have passed on. I
Okay.
don't get along well with my brother. My grandma's, she in the old folks home with my uncle,
Who's your brother?
Buck Hicks,
Okay.
Willard, Virginia King, and my grandparents. But they're all dying, they're getting old.
Well, Buck Hicks is old.
He's getting old. He's 7 years older than me.
I remember years ago, I dealt with him on an issue. All right, 1 o'clock. Mr. George, you don't need to be back because you've made a plea offer of 1 count.
Yes, sir.
One count of trespass. All right, Mr. Hicks, we're gonna work on this. Probably someone from Lisa is named Lisa is gonna be contacting you at the jail and see what our options are.
I'll contact Lisa today.
All right, thank you. You're good to go.
Thank you.
Thank you all.
Now, my Miranda rights haven't been read to me yet. Does that state any or mean anything?
No, people sometimes have the mistaken belief that you have to be advised of your Miranda rights. They only have to advise you of your Miranda rights if they want to ask you anything.
Okay.
And if they do, and they want to use your statements against you, but there's no so all encompassing, you have to be charged with your Miranda rights before you can be charged with something.
Yes.
All right, you go with the court officer. We'll work on the other stuff. All right, Mr. Hicks, you're good to go. We have returned to the preliminary examination and other matters on Dusty Hicks. Mr. Hicks is here with his lawyer, Mr. John Bush. He is in custody. He's charged in file 24998 with 2 counts of resisting and obstructing a police officer as a habitual offender. He also has 6 trespass or disorderly person charges from the city of Three Rivers. We were here on the 24th. I brought the wrong files. Brought tomorrow's files. Laura, would you bring me the Dusty Hicks file? It's in my top tray for this afternoon. Anyway, at the hearing, Mr. Hicks and I had quite a discussion. The offer was a misdemeanor, dismissed the other misdemeanors. He's now been in jail for 24 days. I was, or somebody was, I guess I took it upon myself to contact Lisa Inatelli at the jail. She is our mental health liaison. And I wrote an email and I CC'd it to Tim George, Jeanette Jackson, David Marvin, John Bush, and it was to Lisa, but I never actually sent it. I found it in my drafts this morning. So, Mr. Hicks, I had asked, I found it this afternoon, to have Lisa from the jail meet with you. You've been in jail now for 24 days. We have all of these trespass charges that have been filed against you. And they want to keep you out of that plaza. The resisting obstructing charge allegedly occurred on June 8th. The trespasses start in January. There's a disorderly person in file 24153 from January 23rd. There's a trespass in file 24619.
By this point, the case has escalated beyond a routine misdemeanor hearing. Mr. Hicks has now spent over 3 weeks in custody, and instead of charges resolving, they've multiplied. Notice how the judge carefully lists each case and date. This isn't just one incident. It's a recurring pattern over several months. This matters legally because repeated trespass incidents weaken any argument that this is simply confusion or a one-time misunderstanding. From the court's perspective, the pattern shows continued behavior despite warnings and prior enforcement. But there's also another dimension. Incarceration itself often worsens instability. Someone already struggling with housing or mental health leaves jail even more disconnected from work opportunities and support systems. Judge Middleton is clearly trying to balance two goals: protecting businesses and the public while also avoiding unnecessary punishment for someone who might need treatment rather than jail time. And viewers should consider this. At what point does repeated minor crime become a sign of deeper systemic failure rather than just personal responsibility? Because what we're watching now isn't just legal processing, it's the system struggling to decide how to break a cycle that keeps repeating. And unfortunately, the next exchange shows why resolution is still slipping out of reach.
From April 14th. There's a trespass in 24371 from February 8th. There is a trespass in file 24569 from April 8th. There is another trespass, 24663 from April 20th. And then there's a trespass from April 23rd, and then the closest one is June. As I indicated, the city would take a plea to one, dismiss all of the others, and time served 24 days. The problematic case, and the bigger one, is the felony case, where the city offered to, or the county prosecutor offered to reduce it to attempted resisting obstructing a police officer. The problem is you believe that somehow you have ownership or some property interest in a parcel of parking lot there in that plaza. Mr. Hicks, have you given this some thought since I talked to you last week?
I didn't know I assaulted any police officer.
Well, it's resisting, let's see specifically, which is different than assaulting.
I don't know how I'd be charged with that.
Yes, that's why this was.
No, the thought is due to my family heritage, and a lot of my family owned a lot of property in the area. There's some of the right for me to be in the area when they had built these places and moved in, like Dollar General and Goodwill, stated I had the right to be around there over 100 or 200 feet around the building. I was in an empty area of that building, so I wasn't bothering anyone.
This is the moment where the judge likely realizes compromise may no longer work. Mr. Hicks is still firmly holding on to the belief that family heritage or tribal connections give him the right to remain on the property. Legally, this defense simply doesn't exist for privately owned commercial property. No matter how sincere someone is, courts must apply established property law. And that's why the judge's patience, though still respectful, begins shifting toward a more decisive tone. What's important to notice is that Mr. Hicks isn't acting defiant here. He seems genuinely convinced. That distinction matters because courts handle willful disobedience differently than possible mental health confusion. Also, the resisting and obstructing charge isn't about assault. It's about struggling or interfering with police duties. And those situations often escalate quickly, especially when someone feels they're being unfairly targeted. So now the judge faces a choice: continue negotiations or acknowledge the deeper issue preventing progress. And here's a question for viewers. If someone truly believes they're in the right, even when legally they're not, how should the justice system respond? Punishment alone rarely changes belief, and that reality is about to drive the judge's final decision.
And no one came and told me that I was trespassing. The police just show up and say I am. I don't know
Well,
if anyone,
that's not
because
true.
they
You're
keep
not-
asking me when I
Well,
go
the owner keeps calling and saying, please get this guy out of here.
from California.
I'm not sure where he
And he
is.
said he lives in California because I asked why wasn't he down there? Or I thought I asked, may not have, but I thought he had to be there just like anybody else to witness that I was the trespasser or I get to see them.
No, he doesn't. Anyway, there
So I
was,
feel I was being harassed a little bit by the police. It's the same police most of the time, but
well, it's
No.
the same shift. So we're at
That
the
makes
same point we were at.
But- yeah, no, I wasn't, it's just the tribal and the thing in the center, that park, that's affiliated with my bloodline and my family. That's another reason why I would be allowed to be down there. The history of the 7 tribes. It's just like the 3 chiefs of Three Rivers or Princess Mishawaka, she was born here in Three Rivers, so, it's all heritage, and I'm part of that heritage. So I don't see how I was trespassing. And the symbols on my hand match the pavement. The symbols are dusty. The noble bird, no, it's even in the cell I'm sitting in, the electrical wires,
Your Honor, I don't know if it's a benefit.
Yeah, I
to
don't
keep
know.
talking.
We're at the same loggerheads we were. I don't think we have any choice. I'm going to refer Mr. Hicks for competency evaluation.
excuse.
I'm gonna send you
May I
to the
ask why?
forensic center because you have a delusional belief that somehow you have some tribal interest in this property. And you continue to go back to it and you continue to be
Well,
arrested.
you asked me why.
Well,
Didn't I
I
answer
believe,
why?
And here it is, the turning point of the case. Judge Middleton reaches the conclusion he'd been trying to avoid. A formal competency evaluation is necessary. This isn't punishment, it's a legal safeguard. Competency evaluations determine whether someone understands court proceedings and can assist in their own defense. If not, the case can't ethically move forward. But there's a serious downside. These evaluations often mean extended jail time while waiting for assessment. So, ironically, a process meant to protect defendants can keep them incarcerated longer. Notice how the judge explains his reasoning directly to Mr. Hicks. He acknowledges that Hicks sincerely believes what he's saying, but sincerity alone doesn't make a legal defense valid. The judge also references a previous local case involving someone with persistent delusions. And he's drawing from experience, not frustration. And emotionally, this moment feels heavy. No one in the room seems happy about the decision. But sometimes courts must choose the least harmful option among imperfect ones. From here forward, the case shifts from criminal resolution to mental health evaluation, and the outcome becomes uncertain.
I believe you believe what you're telling me.
Right, but you was asking me that.
Well, I did, and
Oh.
so I'm not mad at you.
Oh, I just thought
Um,
saying you're like a
no,
priest
but
or
I
something.
don't. Yes,
I'm part of the Indian.
I think even if you were full-blooded Indian, I'm not sure that you have a claim to ownership of this property. And
But
you and I
there
just
is
can't.
paperwork somewhere about the sidewalk. Like the symbol is on the sidewalk. I took pictures, but it's in my backpack.
Paperwork somewhere in some alternate universe. The problem is in this case, the police came and they ended up having a big struggle. And you were quite agitated, whether you remembered or not. It was a struggle there in the parking lot, and there were pepper spray and 2 pairs of handcuffs, and you were quite agitated when you got to the jail. And no matter how many times me or the police or someone tells you you can't go back there, you continue to believe that you can go back there. So the question is, are you competent to assist your counsel in defending your case? And are you able to understand the nature of the proceedings against you. I think you understand the charges, but I think you have a delusion that you have a defense. We have a man in Three Rivers, he's not here anymore, but he had what mental health called a baseline delusion that he owned all of the Shell stations. He did not. And he kept going into the Shell stations and pouring himself a cup of coffee and ordering the staff around. And he got arrested about 42 times, literally. When he was on his medication, he did much better. I don't really want to do this, but I don't think I have a choice. We were concerned about how long this would take, but we can't ignore the pink elephant in the room that we're looking at a mental health issue. So I'm still going to ask Lisa Telly to meet with you, but I'm going to sign an order for a competency evaluation. Mr. O'Bear, the people concur?
Yes, Your Honor.
Mr. Bush?
I think it's necessary, Your Honor. I've had that concern.
Judge Middleton's phrase here cuts right to the core of the situation. Courts often try to resolve cases efficiently, but sometimes underlying problems simply can't be ignored any longer. The judge makes it clear, continuing to process trespass charges without addressing mental health would only repeat the same cycle. Arrest, release, return, arrest again. But here's the difficult reality. Courts are not mental health treatment centers. Judges, prosecutors, and defense attorneys are often left navigating gaps in social services, housing access, and psychiatric care. And notice how, even after the decision, the judge still tries to involve jail mental health staff first. That shows reluctance, not eagerness to send Hicks away for forensic evaluation. And this moment reveals something viewers rarely see. Judges making decisions not just based on law, but on practical outcomes. Letting Hicks go right now likely leads to another arrest. Keeping him locked up without treatment solves nothing, so the court chooses intervention, hoping it stops escalation before something worse happens. And as we approach the end of this hearing, you can feel everyone realizing the situation remains unresolved, only paused.
Continue this to June 17th.
Excuse me, you said June 17th.
September, excuse me.
September 17th?
Can be faster. After Lisa meets with him, perhaps we could address a bond issue. But at this point, I'm not confident that if I let him out, he isn't going to go right back to where he was.
I'd like to be out so I can get a job. I mean, if there's gonna be a fine somewhere, I gotta pay it somehow. Otherwise, sitting in there anyways, of the $15-30 a day that they're gonna screw me over with later anyhow, like they did my license.
I don't think you'll be able to pay that, but I understand.
You know, I gotta do something with myself. Sitting in there ain't gonna do nothing.
Yes.
Brick walls, same TV show all day long.
What show do they watch?
Well, I like the History Channel, but it's
This is perhaps the most human moment in the entire proceeding. Mr. Hicks expresses a basic desire shared by many defendants: to work, earn money, and move forward. Sitting in jail doesn't fix employment problems or housing instability, but the judge's concern remains. Releasing him without addressing underlying issues risks repeating the same cycle. Courts often face this impossible calculation: individual freedom versus community stability. You can hear frustration creeping into Hicks's voice. He's thinking practically, fines require money, money requires work, and work requires freedom. From his perspective, jail blocks progress. Yet from the court's perspective, release without change likely means returning to prohibited areas and facing new charges. And viewers should ask themselves, how does someone rebuild stability while stuck inside the system? It's a question with no easy solution. This exchange reminds us that legal cases involve real people, not just charges and paperwork. And sometimes, even sincere intentions collide with complicated realities.
auctions and whatever that making metal, the name of that is.
Mhm.
I'm more into the superheroes and G.I. Joe shows.
Excuse me, what time of day did you say?
That would be
For the
8:30. It can be accelerated. Court will execute a petition for competency evaluation,
So is that for 8:30 or 1 on that?
8:30.
Thank you.
Prelim would be the following week, which would be September 24th. All right. Miss Lisa from the jail is going to come meet with you. You're always polite, respectful, cordial. We just have a fundamental disagreement on your ownership of this property.
He did share with me today, if he was released, he would probably go to Keystone and ask for housing assistance.
All right, we'll hear what Lisa has to say. All right, Mr.
How long
Hicks.
would that be if she does, if I can get to Keystone, because by September, they're not gonna want to put me in there.
Judge Middleton's closing remarks reveal something important. This case isn't about hostility or courtroom drama. Mr. Hicks has been respectful throughout. The issue isn't behavior in court, it's behavior outside it. And that's why this situation is so difficult. Courts are built to handle crimes, not ongoing social and mental health struggles. Yet judges frequently find themselves addressing exactly those problems. The judge even notes Hicks plans to seek housing assistance, a positive sign. But until stability is secured, the risk of returning to restricted areas remains. What stands out here is the judge's tone. He's not angry. He's disappointed that no better solution exists at this moment. The decision feels procedural, not personal. And as this hearing wraps, we're left with uncertainty. Will evaluation help? Will support services step in, or will the cycle continue? That uncertainty brings us to the final takeaway from this case.
I mean, maybe if they ain't said like the last time that they spent money. I mean, I was just about having employment where we were before I got over here, but you know, it ain't gonna do me no good in here.
All right, well, keep you safe, keep the public safe.
Not a threat. I didn't run.
Well, you're right, although there was a fight here with the police that I
wasn't
don't want to
fighting.
minimize.
I felt like that, I sat down like I stated. I didn't throw
All right,
it.
well, don't tell me any more about it, Mr. Hicks, but we need to try to get to the source of this. All right, you're good to go with the officer.
Thank you. Thank you, Judge.
Thanks, Judge.
Stick around for a minute, gentlemen. We tried to finesse it, but I don't think there's any finesse. I think he needs an evaluation. All right, we'll see what Lisa's got for us. Thank you both.
I believe he's sincere in his belief. I mean, obviously, they're not factually based, but
Well, he said to me, you asked me, and he's right, I did, but we're not getting anywhere. And we could have a prelim and present probable cause evidence, but the same problem would exist in circuit court. And then you'd have a competency evaluation, so we might as well bite the bullet. And I'll do the order here forthwith. Thank you.
all right. I guess my concern is like yours is whatever day you let him out, I suspect he's gonna go right back there.
All right, thank you both.
Thank you, Judge.
As the courtroom empties, Judge Middleton sums up what many watching have already realized. There was no simple solution here. The court tried negotiation, plea options, and mental health outreach before finally deciding competency evaluation was unavoidable. In summary, Mr. Hicks faced multiple trespass charges and a resisting and obstructing case stemming from repeated incidents at the same commercial plaza. Prosecutors offered deals that could have resolved the minor charges quickly, but ongoing concerns about his understanding of property rights and court proceedings made resolution impossible without further assessment. The judge's final ruling sends the case toward competency evaluation, delaying proceedings but aiming to ensure fairness and proper treatment moving forward. The broader implication is clear. Courts are increasingly forced to handle issues rooted in homelessness and mental health, not just criminal behavior. This case reminds us that justice isn't always about punishment. Sometimes it's about recognizing when someone needs help before accountability can even begin. And now we want to hear from you. Do you think the judge made the right call here? Should Mr. Hicks have been released, or was evaluation the safer path? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.